A major Supreme Court ruling has quietly landed, and almost no one is talking about it, even though it changes how police forces judge during traffic stops in a way that affects every single person on the road, especially if you legally carry a firearm. This decision reshapes how courts look at police shootings, and in the worst-case scenario, it could determine whether the truth comes out or whether everything gets buried behind a legal technicality. What makes this moment so rare is that all 9 justices agreed. No ideological split, no political divide, absolute unanimity. When that happens, it's a signal that something foundational just shifted beneath the surface of American law. Before getting into the details, let me ask you something important. How often do you actually hear about Supreme Court cases that directly affect what happens to you during a routine traffic stop? Not theoretical issues, not abstract debates. Real-world moments where stress, confusion, fear, and split-second decisions collide. Most people don't hear about these changes until after something goes wrong. That delay can be devastating. What you're about to hear isn't being widely discussed, but it directly shapes your Fourth Amendment protections the next time red and blue lights flash behind you. Here's what happened. In mid-May of 2025, the Supreme Court released a decision in a case that now stands as a turning point in how use of force cases must be evaluated. The case involved a fatal traffic stop, a police officer, and a long-standing legal shortcut that had been shielding questionable conduct from meaningful review. For years, certain federal courts used a narrow lens that allowed them to ignore nearly everything that happened before a shooting, focusing only on the final instant when the trigger was pulled. That shortcut is now gone. To understand why this matters, you need to understand the constitutional foundation underneath it. The Fourth Amendment protects people from unreasonable searches and seizures. A traffic stop is a seizure. An arrest is a seizure. And yes, when an officer uses deadly force, that is also legally classified as a seizure. The Constitution doesn't prohibit all seizures. It prohibits unreasonable ones. The challenge has always been deciding what reasonable actually means when emotions are high and seconds matter. For a long time, several federal appellate courts adopted what became known as the moment of threat approach. Under this method, judges were instructed to look at only one sliver of time, the precise moment when the officer claimed to perceive a threat. Everything else was excluded. It didn't matter how the situation unfolded. It didn't matter whether the officer's own decisions escalated the encounter. It didn't matter if safer alternatives were ignored. If the officer could point to fear in that final instant, the analysis stopped there. That approach created a deeply distorted view of reality. Real encounters don't unfold in frozen snapshots. They are chains of decisions, reactions, commands, misunderstandings, and movements. By cutting off the timeline, courts were effectively erasing context. And context is where responsibility lies. The case that finally forced the Supreme Court to address this involved a traffic stop outside a major Texas city nearly a decade earlier. A county officer received information that a vehicle traveling on a highway was associated with unpaid toll violations. Nothing violent, nothing urgent, just a routine administrative issue. The officer initiated a traffic stop from the outside. It looked like countless other stops that happen every day across the country. The driver pulled over. The officer approached and asked for identification and insurance information. The driver explained that he didn't have his physical license on him, and that the vehicle was a rental registered to someone else. He began searching inside the car for paperwork. The officer told him to stop moving around. The officer then claimed he detected the odor of marijuana. The driver suggested that his identification might be in the trunk. At that point, the officer instructed the driver to open the trunk from inside the vehicle. The driver complied. As he did so, the engine was restarted. What happened next unfolded rapidly. The officer opened the driver's door and drew his firearm. The vehicle began to move forward. Instead of stepping back, the officer leapt onto the outside of the moving car, clinging to the door frame, while positioned on the exterior of the vehicle. With limited visibility into the interior, the officer shouted commands for the driver not to move. Seconds later, while still hanging onto the moving car, the officer fired multiple shots into the vehicle. The driver was struck. Despite being mortally wounded, he managed to bring the vehicle to a stop. The entire sequence, from the vehicle beginning to move to it stopping again, lasted only a few seconds. The driver did not survive, The driver's family brought a civil rights lawsuit, arguing that the officer's use of deadly force violated the Fourth Amendment. They pointed to the officer's decision to jump onto a moving vehicle as the critical escalation. That created the danger, but the lower courts never seriously examined that choice. Instead, they applied the moment of threat rule. They focused only on the instant when the officer was clinging to the car and feared being injured. From that narrow perspective, the shooting was ruled justified. Everything that happened before those final seconds was legally ignored. Think about what that means. An officer could make a sequence of poor decisions, disregard safer alternatives, place himself into a dangerous position, and then use that danger as justification for deadly force. And courts would be required to pretend that none of the earlier decisions ever occurred. That's not how accountability works in any other context. If someone creates a crisis through reckless behavior, we don't normally excuse the consequences by pretending the earlier choices never existed. The Supreme Court unanimously rejected that artificial timeline. In a clear and direct opinion, the court explained that the Fourth Amendment requires judges to consider the totality of the circumstances, not a single moment, not a carefully selected snapshot, the whole encounter, every relevant action leading up to the use of force. The court made it clear that judges cannot evaluate reasonableness while wearing chronological blinders. The justices pointed out that context isn't optional. It's essential. You cannot fairly judge whether force was reasonable without understanding how the situation developed. Actions taken by officers before a shooting may increase or decrease the risk of violence, and those actions must be part of the constitutional analysis. To reinforce this principle, the court referenced earlier decisions where the full timeline was already considered standard practice. In one example, officers engaged in a prolonged high-speed chase that endangered the public. When deadly force was eventually used, the court emphasized that the danger created during the entire chase mattered. You couldn't isolate the final second and ignore the reckless behavior that came before it. The message was unmistakable. You don't get to edit reality to make a use of force decision look reasonable after the fact. This ruling has enormous implications for anyone who legally carries a firearm. Every traffic stop involving an armed citizen carries inherent tension. Officers are trained to treat weapons as potential threats. Citizens are trained to comply while protecting their rights. When communication breaks down, the risk skyrockets. Under the old framework, if an officer gave confusing or contradictory commands and then reacted violently to the confusion he created, courts in some regions would ignore that setup entirely. The final motion of a hand or a shift in posture could become the sole focus, detached from the officer's instructions that caused it. That's no longer acceptable. Now, courts must ask harder questions. Did the officer's commands make the situation more dangerous? Did the officer ignore de-escalation opportunities? Did the officer put himself in a position where deadly force became likely when safer alternatives existed? Did the officer's actions compress time and space in a way that left no room for compliance? All of those questions are now constitutionally relevant. Imagine a lawful gun owner stop for a minor traffic issue. The driver follows the law and informs the officer that they are carrying. The officer becomes visibly nervous. Commands come quickly or without clarity. Hands up, hands down. Reach for your wallet. Don't move. The driver attempts to comply, moving carefully and slowly. The officer panics and fires. In the past, some courts might have focused solely on the movement of the driver's hand toward their waist. Fear in that instant could end the analysis. Now, the entire exchange must be examined. The officer's instructions, the timing, the lack of clarity, the failure to control the environment before issuing commands, the legality of the stop itself, all of it matters. That shift doesn't guarantee a particular outcome. It doesn't automatically mean officers will lose cases. What it means is that courts can no longer pretend that only 1 second of reality exists. One of the most telling aspects of this decision came from a concurring opinion that spent significant time acknowledging the dangers officers face during traffic stops. The justices, writing separately, went out of their way to explain that policing is difficult and often dangerous. They recognize that officers make decisions under stress and uncertainty, and yet, even with that recognition, they fully agreed that the totality of the circumstances must be considered. This ruling is not anti-police, it's pro-constitution. It does not demand perfection, it demands honesty. It requires courts to evaluate what actually happened, not what's most convenient to analyze. The Constitution does not say that fear alone justifies force. It says that force must be reasonable. Reasonableness cannot be measured in isolation. The Supreme Court did not decide whether the officer in this case violated the Fourth Amendment. Instead, it sent the case back to be reevaluated under the correct standard. That means the lower courts must now examine the officer's entire course of conduct, including the decision to jump onto a moving vehicle. What happens next in that specific case remains to be seen, but the broader impact is already clear. Police departments will need to rethink training. Prosecutors will need to reevaluate how they review use of force incidents. Civil rights attorneys now have binding precedent that demands a complete factual analysis. There is another layer to this decision that deserves attention. The court deliberately avoided answering one critical question: whether an officer forfeits the right to use deadly force if he intentionally or recklessly creates the danger that leads to it. The court noted that this issue wasn't properly addressed by the lower courts due to their narrow focus, so it remains unresolved. That silence is not accidental. It signals that the court recognizes the importance of the issue and expects it to return. When it does, this decision will serve as the foundation for armed citizens. This matters deeply. Confusion during police encounters can be deadly. Inconsistent commands can create movements that are misinterpreted. Under the new framework, courts must confront whether the confusion itself was foreseeable and preventable. This ruling does not mean that lawful force is prohibited. Officers may still defend themselves against genuine threats. The Fourth Amendment has always allowed reasonable force. What this decision prevents is the use of a legal blindfold. To excuse unreasonable escalation, context is no longer optional. History is no longer erased. Responsibility cannot be confined to a single second. The legal landscape has shifted, and it shifted unanimously. That should tell you something. When all 9 justices agree the courts have been asking the wrong question, it's not politics, it's correction. The Fourth Amendment still applies in tense moments. It still applies when adrenaline spikes. It still applies when decisions are made quickly. And now, courts are required to respect that reality by examining the full story, knowing this matters, not after something happens, before it does, because constitutional rights don't protect you retroactively. If no one understands them in the moment, the Supreme Court just reaffirmed that reasonableness requires context, that justice requires honesty, and that constitutional protections do not disappear just because the clock moves fast. That knowledge could change how encounters are judged, and in the worst moment of someone's life, it could change whether the truth is fully seen.